modern day divorce, we end up settling the overwhelming majority of our cases. I started in this firm, hired as the firm litigator, and used to spend a great deal of my time in court. And things have really changed, both because of societal influences, and also I think mediation has a great deal to do with the fact that we settle the overwhelming majority of our cases. In this firm, it runs 90 to 95%, and I think that's fairly similar to what it is system-wide. Settling cases seems to most lawyers to be intuitive, and they do what's known as positional negotiation. One side starts high, compromises lower, the other side does the opposite, and in many cases that's fine. But over the years, there's been a great deal of research and literature regarding settlement negotiation strategies. The leading book on the subject is a book called Getting to Yes by Fisher and Urey, and anybody who negotiates for a living really needs to read that book. It's just terrific. On a personal basis, I wrote a book on settlement negotiations in family law, which is available from the American Bar Association Family Law section. And what I tried to do in the book is discuss different aspects of settlement negotiation and some of my ideas towards settlement. But there's a great deal of literature outside the field of family law, particularly in business and business negotiations, that lawyers can learn from. One of the things that I find sort of odd in continuing legal education is it seems to me the vast majority of CLE programs in divorce are on how to litigate a family law case. Questions on calling experts and cross-examination and presenting evidence and use of social media as exhibits and as evidence, which is all real interesting stuff. But we settle 90% of our cases. Why is 90% of the CLE on how to litigate? If 90% of our cases are resolved, maybe it would be interesting for lawyers and more important and more relevant to their practice if 90% of CLE was on how to resolve cases. I think some lawyers, I said, are resistant because you just think it's intuitive. Well, I'm going to tell you that it's not. And I'm going to talk to you about a program coming up this November put on by the Cooperative Divorce Institute, in which the CDI will be discussing various aspects of settlement, including mediation and negotiations from an ethical point of view, so there'll be some EPR. But the keynote speaker is going to be Professor Ray Aldig from the University of Wisconsin. Now, he's a business professor who specializes in business settlement negotiations. And I've heard Professor Aldig speak before. He comes at it from a unique aspect. It's not from a family law aspect, but it's from a negotiations aspect. And he'll go into the research, what some of the studies have done, and what they have shown in terms of how to effectively settle cases. The seminar is on November 13th, 2015 in Delafield, Wisconsin. You can get more information by going to the Cooperative Divorce website, which is www.cooperativeddivorce.org. And I would suggest looking into this. Professor Aldig is going to discuss areas, ideas, thoughts, and strategies about negotiations that are not intuitive, that are the subject of a great deal of research, a great deal of professional studies, a great deal of literature that have gone into this. It's what we do most of the time. Let's learn how to do it better.